start in about 2 minutes.
Good afternoon. Our next case is State v. Farook, and we will hear from the appellant.
May it please the court. My name is John Congleton. I'm an Assistant Attorney General. I represent the state in this matter. The Court of Appeals erred when it held that the admission of testimony by James Davis was plain error. The trial court committed no error, let alone plain error, in the admission of this testimony because Mr. Davis did not testify as to privileged material. This court should reverse the Court of Appeals where the trial court properly found there was no speedy trial violation based on the testimony of Mr. Davis and the other evidence. Even if this court believes that the testimony was privileged, the Court of Appeals erred by rejecting all of it, or probably some of the testimony was privileged. Court of Appeals erred by rejecting all of it and finding a speedy trial violation where the defendant never asserted the right to a speedy trial prior to moving to dismiss and presented no evidence of prejudice at the hearing. And if this court agrees with the Court of Appeals that all of the testimony of Mr. Davis was somehow inadmissible, the defendant's failure to object to that at the motion hearing it means there was no reason for the state then to provide evidence from other sources or knew of no objection, and this court should remand it back to the trial court so that the state can present evidence. Now, we begin in this case specifically with this issue of attorney-client privilege. And it's a strange occurrence where the defendant in this case filed a motion to dismiss, roughly 6 years, or I think beyond 6 years past the institution of the charges. And the defendant's counsel at the time, upon filing it, essentially reports to the court, I don't wish to really put on evidence, I just wish to argue afterwards. And this goes towards the general standard in speedy trial jurisprudence, which is to say that the courts have held, and I'll cite to Barker versus Wingo, of course, as one of the stalwart cases. Oh, if I may, I would like to reserve 5 minutes of my time. I'm sorry, I stepped ahead of myself there. In doing so, the first issue, of course, is the length of the delay. And obviously in this case, the defendant was charged in June 19th of 2012. He was ultimately tried October of 2018. So it's approximately 6.5 years. So the initial length of the delay under Barco will trigger then the court having to weigh these analyses, the remaining Barker factors. And that's where the motion hearing went. The state then called James Davis, who had actually been defendant's counsel for a significant period of this time. He had been appointed, I believe, August of 2012 to represent the defendant, and then he subsequently withdrew in July of 2017. I want to say the specific date was July 5th. But what occurred throughout the middle of this and the pendency of this, and it was testified to Mr. Davis, was that there was a number of things going on. Number one, he indicated that there was a lot of murders in Rowan County, that he himself...
Is Ms. Holliday correct in arguing that Mr. Davis was not under subpoena?
I see nothing in the record there is no subpoena in the record.
So as far as you can tell from your examination of the record, he was there voluntarily?
Of his own volition, Your Honor. And when he was called, defendant did not object to his being called, and Mr. Davis himself did not object to being called. And Mr. Davis then presented evidence to a number of things. Number one, he indicated there was, of course, voluminous discovery based upon the facts of this case. There was an accident reconstruction. There were labs that were taken. There was DNA that was collected. Just a lot of those things that needed to be dealt with. As well, what's telling is that Mr. Davis testifies that as this thing goes along, it's on admin calendar specifically to find out where the case is and to discuss the case. And he discusses the case with the DAs. And if I may back up, when Mr. Davis was appointed to represent defendant, the first thing he did was he sent an attorney from his office to go and speak with defendant and discuss the case with him. And that was done, at least from the record, it appears to have been done in close proximity to his being appointed in August of 2012. And so he sends this attorney, that attorney speaks with the defendant. He's talking to the DAs, and he indicates throughout that as he's talking to the DAs about this case, he's discussing with them the strengths, the weaknesses, the age of the case as it progresses. And I'm paraphrasing a little bit here, and I apologize if it's not exactly the way it was stated in the record, but specifically not need, but perhaps the desirability for the state to offer a plea to his client. And very early on in the process, he notes that the DA actually informs him that they are very interested in indicting the defendant as well on violent habitual felon, which carries a life without parole. And so early on, they have indicated to Mr. Davis, that's what we're interested in doing with this case, violent habitual felon. And later, as Mr. Davis begins speaking to the DAs about, I guess, seeking a plea or showing interest in seeking a plea rather than a trial, because he does not testify that he was asking them to calendar it. But as they meet, he talks about a plea, and what occurs is he's concerned about the violent habitual felon specifically. And so he states and he testifies, it's my strategy, I do not want to push this to trial because I know violent habitual felon is coming. And I want to try to get a plea. And at least that's the way the record reads to me. And it's careful how he testifies. And I will say that I think that they were being careful not to cross into things I think that would clearly be.
Your colleague argues, though, that this testimony about the strategy that Mr. Davis was employing perhaps might not have been covered by the attorney-client privilege, but is covered by the work product privilege. I didn't see anything in your brief discussing the work product privilege. Am I missing something?
Not specifically, Your Honor. This is a bit strange. It was raised as an attorney-client privilege issue below, not as a work product issue. And work product seems to relate to materials that are produced.
Does it also apply to the mental impressions of counsel?
I think that it does, to the extent that it is either put on paper or that there are materials or things that are created that would get into.
So it's your testimony then that the work product privilege that's discussed in State versus Hardy only applies to documents?
I'm not going to say that's my testimony, but I would say
I hope you're not testifying at all.
But it seems that in a lot of the cases, it talks about that the work product is limited to actually things that are produced, tangible things. And I think there is a distinction between, of course, attorney-client privilege and work product, such that since work product wasn't brought up below, we're looking at this specifically in relation to attorney-client privilege.
So your contention is work product was not brought up before the Court of Appeals?
Well, the way I read the assignment of error was attorney-client privilege. That's the way I read the
What about the argument in the brief?
Well, again, Your Honor, I think that there were no materials sought here.
So your argument with respect to work product privileges is essentially that there were no documents, therefore the privilege doesn't apply?
I would say that the privilege didn't apply here.
Okay.
And as well, and it's a strange thing, and I have to do a mea culpa, I think, here as well, because I believe in retrospect and looking at this, in this very issue before the court, that perhaps I failed to see the forest for the trees. Because the interesting thing is the court below applied the plain error standard, and as well, that may not have been the correct standard, though we didn't. I should have perhaps delved into that and did not. I did not recognize that perhaps that the wrong standard was being applied there. Again, mainly because the testimony that was before the court in the motion to dismiss was not testimonial in the sense of it was not testimony to be placed before the jury. None of this evidence that was brought forward there was actually evidence. And in looking at this court's opinions and this court's holding, it talks about where there's this, plain error, if you will, that has a probable impact on the jury's finding of guilt. And here, none of the evidence that was being discussed here was ever going to be placed before a jury. This was purely, I'm not sure of the word, I'm not going to say administrative. It was certainly testimony, but it was never intended to be evidentiary for purposes of convicting the defendant. This is merely sort of pretrial whatever. And so if that's the case, and this should be treated the way this court has treated, I think, most of the other cases, which is that it's evidence before the jury as opposed to before a judge, which can be presumed to disregard incompetent evidence, I think that perhaps plain error shouldn't have been applied there. Perhaps it should have been a simple waiver issue. But again, in all candor to this court, I didn't fully appreciate that issue until it came up, and I'm reading the briefs, and it's, there's some quotes in there that, don't match up with the characterization of the quotes doesn't match up with the actual language used by this court, which is to say probable impact on a jury's finding of guilt. And the cases seem to indicate that the plain error is limited, of course, to jury instructions, and again, evidentiary issues generally that are brought before a jury where it can't be corrected because the jury has heard something that should have been brought up. And I bring that up just to say, despite my failure to sort of recognize that may be a important argument there, I still think the court has to ensure that it applies the proper standard, whatever this court determines it to be, in its analysis. And I certainly don't want to be accused of not bringing that forward and potentially walking the court into an unfortunate opinion, or at least be aware of that as it drafts its opinion in this case, so that it don't want to be complicit in potentially having an opinion go out in the wrong manner.
So if I understand, is your argument now to us that it's all right for an attorney to divulge attorney-client protected information as long as it's not going to go in front of the jury?
I think that where the attorney, where there's no objection to it, I don't think the plain error standard applies. This does not mean that it is necessary. I'm saying that that's a good thing or that that's whatever, but I just think that if there's no objection to it, and Mr. Farook, as I read the transcript, was in the courtroom at the time this was argued. He was represented by counsel at the time this was argued. His counsel, all of whom are licensed attorneys, knowledgeable, experienced attorneys, no one objects.
Right, but isn't it the attorney's responsibility not to divulge attorney-client protected information?
I would say yes if the attorney believes that it's attorney-client privileged information.
All right, so when counsel is asked about conversations that he had with his client, on page 50 of the transcript, prior to this June 14th offer, and then your time talking with him about the offer, did he ever indicate to you or tell you that he wanted a trial in this case? Isn't what the client told the attorney privileged information?
The answer to that, as I recall, was that he had never stated that. So there is no communication in the sense that had the defendant, let's say, told Mr. Davis, I want a trial, or I want X, Y, or Z, then perhaps we go down that line. But I think the question there was not, what did your client tell you? It was more, what specifically did your client tell you? It was this your strategy? Were y'all looking for a trial? Is this something that was there? And he says no. And I think that's supported at least by the evidence in the record where Mr. Davis indicates that each time he talks with the DA and he talks with them about the case, and yet he's clearly not asking that the case be calendared. He's not asking that the case be put to trial. He's not filing a motion asking for a speedy trial, saying, hey, put this on. Nor did Mr. Bingham. Now, albeit Mr. Bingham, of course, was only appointed for approximately 3 months in 2017. Mr. Cease as well, when he took over the case, did not file a motion saying, hey, we want our speedy trial and we want it now. In fact, nothing occurs until September of 2018 is when we get to this hearing, if you will. September of 2018, I think September 11th or so is when the actual motion was filed finally, not saying we want a speedy trial, bring us to trial. It was already on a trial calendar at that point, but now we want a dismissal. And as an adjunct to that motion, there's no affidavit that, I wasn't aware of this. There's no, it's pretty much just a blanket, it's been 6 years, therefore there's prejudice, and therefore it should be dismissed. And the interesting thing, and I'm jumping back and forth between issues here, and I'm sorry to move away from the attorney-client privilege, but ultimately, how do you get to this information? How do you ever get to this information if you don't get it from whether it be a defendant or an attorney? If it's not, if it's not asserted, how do you get to why? You don't. I think, and that's the sort of the issue we sort of hit on in our brief, I think, is that the interesting thing is this defendant was represented by counsel the entire time. And granted, this was 6.5 years. I'm not going to try to say this was 2. but he was represented by counsel the entire time. He raises no competent ineffective assistance of counsel motion. He takes no exception to his counsel's actions anywhere in here. He could have filed those motions. He could have made those allegations. He could have testified at the hearing. He's silent. He's apparently, at least according to the record, satisfied with his attorney's representation. And the Supreme Court, the United States Supreme Court, even mentions that in the case of Barker versus Wingo, and it makes a comment, and I made note of it because I thought it was important, that they themselves would actually take a look at it, and they themselves would actually address it. And what they basically say, and I thought I had it right on the top of my stack, I do not. Apologies there. But what they basically say is, where a person never doesn't actually go in and raise this, and they brought forward no allegation of incompetence or whatever of their counsel. I have the quote here. It says, I've got my papers, I'm sorry. But what it basically says is counsel was appointed for Barker immediately after his indictment and represented him throughout the period, and no question is raised as to his effectiveness or whatever. And so I think even the court in Wingo sort of recognizing that you can't not assert that right and then sit silent later on for however long a period of time, and then later on say, well, that was my counsel's fault.
Would the defendant have the right to file a motion for appropriate relief, allege that he had received ineffective assistance from his trial counsel?
I think a defendant always.
No, that's fine.
I think a defendant always has that right. That's something that's out there where they can do those sorts of things. In fact, I think counsel has alleged in their brief this is probably something this is something we may well do at a later point. And I can't. There's nothing I can do with that here. If they wish to raise that, that's fine. And of course, then a court can delve into all of these other issues about those things, because at that point it opens it up for a court to actually analyze what was happening and actually analyze how these things were occurring, not simply speculating. There's so much speculation in this case. One of the things, for instance, when we get later on and we start weighing these factors, for instance, is, well, he wasn't indicted for second-degree murder until 5 years after the initial charge. But he knew that violent habitual felon carrying life without parole was pending from very early on in this process. And we can't speculate. And Mr. Cease even makes that statement in his argument. I'm not going to speculate. I can't speculate. That this was out there.
When you say the defendant knew that this was inevitable, that he was going to face greater charges, was that during the time that his attorney was not having any consistent contact with him, which is shown in the record?
Yes, in the sense that he states that, I want to say Mr. Davis testifies that he becomes aware of that in 2013. Very early is the beginning when he says, hey, they've indicated they want to do this. And again, in 2014. And I think, Your Honor, if you actually look at the timeline, if my recollection is correct, it's around March of 2014 when he meets with one of the DAs. It comes up again. I think this is when they indicate, hey, look, remember, if this thing's going to trial, I'm going to indict on violent habitual felon, which, again, it had come up before. And at that point, that's when he sends counsel back to meet with the defendant a second time, or an attorney in his firm. Now, I want to make it very clear, there's no evidence in the record, of course, that Mr. Davis himself met with Mr. Farook at that time. He sent other attorneys in his firm to go and speak with them and actually discuss the case with him. So, but he was...
Is it attributable to defendant's awareness, though, that these greater charges were coming at him if his attorney was not, as is shown in the record, and apparently it is uncontroverted, was having no contact with him?
Well, again, Your Honor, I'm not comfortable saying he was having no contact with him. He did, of course, have someone meet with him initially. He had someone meet with him again after the meeting I just cited. If I read that correctly, I want to say March 14 of 2014 or somewhere in that area. But we also don't know what other communications there may have been. Now, again, there's no evidence that there were, but we know that following that interaction, they do go and talk. But still, nothing gets asserted. And still, the fact that, kind of my point behind this is more that his counsel knows to the extent that there's an argument that he's somehow prejudiced because there was this indictment that somehow upped the ante later on, it was clear from the beginning that that was probably going to happen if we ended up in that phase. They were interested in indicting him and trying him on that from a very early period. And so counsel was on notice that this is not, that there is a more serious case here, in that the preparation for this case is going to be, I hate to say this, but they're going to be heightened to, this isn't merely a speeding ticket or whatever. We're now facing life without parole, according to what the DA says their intent is with the case. Counsel should not be surprised then to say, well, okay, there's a second-degree murder, and now I didn't know it was going to get elevated. He knew it was going to get elevated. He knew there was a great possibility of it being elevated very early in the prosecution. And I think that undermines some of the prejudice argument, at least to the extent that they say we're prejudiced by the fact that I wasn't indicted on larger charges 5 years after the fact, when they were aware that that was probably the procedure that was going to occur very early in the prosecution. So that being said, it's my argument that there's been a waiver as to the attorney-client privilege, I think. But at any event, most, if not all, and I believe all of what was testified to was fair game in that regard. And so to that extent, then we've got to look at Barker versus Wingo. This court can't sidestep that analysis. It's ultimately what the courts have to do. And in looking at that, we do have the length of the delay, which of course triggers the weighing of the other factors. The second issue that you have is the reasons for the delay. And interestingly there, what we have is testimony from Mr. Davis that this was my trial strategy, that I wanted to delay this case because I knew this thing was hot. I knew that they were going to indict higher. And I think it's clear from his testimony about meeting with the DAs, pressing for a plea, that's what he was looking for. He testifies, Mr. Cease even indicates in his argument after in his argument to the trial court that specifically as to, getting ahead of myself a little bit there, I apologize. But basically even he, in looking at the totality of this, knowing that's coming, says, hey, this didn't come to a head until 2017. The issue of trial, I think that was close to the exact words, the issue of a trial wasn't coming to a head until 2017. Wasn't on the burner. And that's my reading of it. And so you have these plea negotiations that are then going on in earnest with conference of DAs. It comes very close to actually resolving, apparently, according to the testimony, within 10 months difference in the two offers. They're making counter offers. They don't come to a meeting at that point, it's rejected. And so at this point, reasons for the delay, we have testimony that indicates that defendant was acquiescing in the delay. We have testimony, I think.
Well, what is the testimony that the defendant was acquiescing? Is it anything other than what Mr. Davis testified to?
No, it's specifically that Mr. Davis indicated that this was my strategy, was to let...
Well, Mr. Davis testified that it was his strategy. What is the evidence that the defendant agreed to it other than the fact that Mr. Davis never changed strategy himself?
Well, if it please the court, the defendant is represented by counsel this entire time. And defendant does not actually come forward and ever put on any competent evidence that he didn't know. And he doesn't, again, make any argument or any motion as to the effectiveness or whatever. He takes no offense in any of this, at least to this point, to Mr. Davis's actions. And in doing so, you have this testimony, and I think that you have to presume that Mr. Davis is acting as competent counsel, absent some allegation otherwise. And that being said, I think that this is not negligence in a sense. I think he was discussing with the DA and they were making decisions, and I think the DA was taking actions based upon what he was being presented by defendant's counsel. Defendant himself never asserted it for the entirety of the period. He only made a motion to dismiss at the last moment. And then, of course, prejudice, he makes no showing of prejudice. The state indicates, Mr. Davis testifies, and I know I'm getting into my 5 minutes. Mr.
Well,
Davis,
your 5 minutes is about over.
Thank you, Your Honor. I'd just like to kind of finish that thought with, he put on no evidence. The state then put on some evidence that there was no prejudice. Mr. Davis knew where the witnesses were, et cetera, and had no problems with that. So I think the state rebutted any sort of presumed prejudice there. And with this, I'm going to stop. I'm going to reserve my last minute and 20 seconds. Thank you.
Your Honors, may it please the Court. Good to see all of you again. I'm here on behalf of the defendant appellant, Khalil Abdul Farook, who waited more than 6 years for the state to bring his case to trial. He waited in jail, behind bars, deprived of his liberty, his freedoms, his access to friends and loved ones. And when the state was called upon to explain why it took 6 years to get to court, their only explanation was, we were busy. And what's more, they said it through Mr. Farook's own attorney. The sole witness was James Davis, who represented Mr. Farook during 5 of those long 6 years. Mr. Davis testified not only to the content of his communications with Mr. Farook, but also to strategic decisions that he made while acting as Mr. Farook's attorney.
Other than the exchange that I think Justice Earls mentioned with Mr. Congleton, where in the record does it show that Mr. Davis repeated something that Mr. Farook told him during the course of his testimony?
If I understand it correctly, the question is, other than the part of the testimony
page.
about, did you discuss this? Right. Well, there, I'm sorry. That is the primary example of attorney client privilege communications, because there were, I'm so sorry.
Is there another example of a testimony concerning a communication that Mr. Farook gave to Mr. Davis?
Well, I think the answer to that question has to be no, because there were so few communications between Mr. Farook and Mr. Davis.
But just to follow up on that, wouldn't it also be attorney-client privilege communication to the extent that Mr. Davis testified about what he told his client?
That certainly would be. I don't know that there was much testimony about that. All of Mr. Davis's testimonies in the first person. This is what I did. This is what I thought. Other than that one exchange, which clearly implicates attorney-client privilege, there's very little about his interactions with Mr. Farook, because there were none. The Court of Appeals correctly determined that this series of events amounts to an outrageous violation of attorney-client and work product privilege.
Before we move on, I apologize for continuing to interrupt you, Ms. Holliday. I looked back at your brief in the Court of Appeals, and I could not see any reference to the work product privilege, at least in your initial brief.
It's on page 27.
Pardon me?
Page 27, Your Honor.
Thank you.
Of the initial brief in the Court of Appeals. It cites Pravat and says, essentially, if this wasn't attorney-client privilege, it was work product.
Okay. Please proceed.
Certainly. So I wanted to start by talking about the speedy trial issue, because even though we contend that Mr. Davis's testimony was incompetent and none of it should have been heard without proper justification, even if all of that evidence is considered, the state has failed to adequately explain the 6-year delay in bringing this case to trial.
Who has the burden of proof to show that the state acted unreasonably?
The burden is on the state to explain, to provide reasons for the delay. Is that?
So Spivey, our court 2003 says defendant has the burden of showing that the delay was caused by the neglect or willfulness of the prosecution. Do you disagree? Do we need to overrule that?
Well, my position is that particular ruling creates an additional impediment that is not part of the U.S. Supreme Court precedent. However, I think there's both willfulness and neglect in this case, so you wouldn't necessarily have to overrule that today.
So I want to be clear, who has the burden of showing that delay was caused by neglect or willfulness of the prosecution?
So if we're keeping to that standard, I believe what Spivey says is that the defendant has that initial burden.
And how can you carry that burden when you don't put on any evidence?
Well, I think there are a couple of indications in this case.
Now I want to talk about evidence.
Sure. Well, what the defendant has put forward is...
And how is the defendant putting this forward?
Sure. In his argument to the court, in his motion to dismiss for violation of speedy trial...
Which of that is evidence?
None of it is testimony.
Which of it is evidence?
I think it's unrefuted. The state... If you're asking me what evidence did the defendant put on, what they admitted into evidence was the ACES printout, which shows all of the entries into the docket for this case. Essentially that outside of appointment of attorneys and things like that, the case was never on the trial calendar. There were a total of 3 administrative settings in 5 years, none of which Mr. Farook was present for as far as we can tell. And I think when you have years of a case going by, when there's no activity in court and no opportunity for the defendant to be informed about what's going on, that is evidence of neglect.
So who makes a finding as to whether the defendant has presented evidence of neglect or willfulness?
Who makes the finding?
Yes.
I'm not sure I understand the question.
Well, would it be the trial court or would it be the Court of Appeals?
Well, I think the trial court could make an initial finding, which the Court of Appeals could then review.
Isn't that the purpose of the trial court, is to take evidence and make findings of fact based upon that evidence?
Yes, Your Honor.
So is there any finding of fact by the trial court that the defendant carried his burden of proof to show delay, that the delay was caused by neglect or willfulness?
My reading of what happened at the trial court level is that once Mr. Farook came forth with the extensive and extraordinary delay in this case, everyone understood that that was insufficient to shift the burden to the prosecution.
Well, there's a difference between saying that you have to go to the next step and saying that the burden has shifted to the prosecution, correct?
I understand.
So, again, I'm having a hard time understanding either Spivey is wrongly decided or the defendant has the burden to show neglect and willfulness, correct?
Well, let me talk a little bit about negligence and willfulness in this case. So, to begin with, the delay in this case is 6 times longer than the delay that Doggett says is necessary to move the analysis forward, and such an extreme delay is in itself evidence of negligence. This is particularly true because Mr. Farook's case was never calendared prior to his actual trial date. There are no motions to continue, and not once in 6 years did the state affirmatively try to move this case forward. At best, this is negligence.
I'm sorry, Ms. Holliday. Did you say that the case was not calendared?
Correct. During Mr. Davis's representation, I believe there were 3 administrative calendar dates, but there were no trial calendar dates. In terms of willfulness, I think that the evidence that the state put forward at this hearing actually supports a finding of willful delay in Mr. Farook's case, particularly because the timeline of cases that they have set out shows that this case took more than twice as long as the average case of any kind and the average murder case in this county to come to trial. And the state has offered no explanation for what it was about this case that made it particularly difficult for them to bring to court. And they have conceded, I think, that they were hoping to coerce a plea. Doggett tells us that the state's inaction counts as negligence. And in McCoy, this court described a mere 10-month delay as willful neglect. So I think in this case, where we've got 6 years of the state sitting on its hands, it's fair to assume that it was both negligent and willful.
So it's your position that an appellate court, in the first instance, is to weigh the, whatever may be available in the record, and based on that, to find facts that would then support the position of the defendant?
I think perhaps where we're failing to connect is, I do think that that additional step that Spivey requires falls below the constitutional floor established by U.S. Supreme Court precedent. And so, you know, I do think eventually that case does need to be overruled, but I don't think this is the case because of the evidence that I've described.
So one of the factors to be weighed by the trial court is the assertion of the right to a speedy trial.
Yes, sir.
Should that bear here where there was no assertion for a speedy trial until a motion to dismiss was filed?
Certainly. So in this case, let me just skip ahead in my notes. It's correct. Mr. Farook did not file his speedy trial motion until September of 2018.
Well, that's not a motion for speedy trial. That's a motion to dismiss.
Motion to dismiss until.
Wait, and would you concede there's a difference between a motion for a speedy trial versus a motion to dismiss?
Certainly, although I'm not sure practically what the difference is.
Well, except in this case, it was already on a trial calendar.
Mm-hmm.
And so he knew that the trial was imminent.
Certainly. However, the circumstances of this case, I think, are extremely unusual in that it appears that Mr. Farook was represented for approximately 5 years by an attorney who, you know, utterly failed to communicate with him, didn't advise him of his right to a speedy trial, didn't advise him of the mechanism for seeking a speedy trial. The court itself had discouraged.
Do we know any of that?
We know from Mr. Davis's own testimony that he didn't personally meet with the defendant until 2017.
We do know that, but we don't know what information, if any, was given to Mr. Farook. It doesn't appear to me. Is that wrong?
It is in Mr. Farook's pro se motion to dismiss due to a speedy trial. He explicitly says, I was never advised of these things. So it is in the record in that sense.
It's in the record, but that filing was not introduced into evidence, I take it.
Correct.
Let me ask a more basic question than the ones that you've been discussing with the Chief Justice for a few minutes. Assuming you're not contending, are you, that everything in Mr. Davis's testimony was inadmissible, are you?
No, it isn't all necessarily completely incompetent.
I mean, for example, he's, you know, whether a defense lawyer is well advised to do it might be one thing, but there's no evidentiary obstacle to his testifying about his conversations with Mr. Banks, is there?
My understanding of the work product law is that the party seeking to get that information needs to prove both that they need it and that they can't get it from another source.
But is there any obstacle to Mr. Davis testifying that Mr. Banks at some point mentioned to him the possibility of a murder indictments and the possibility of charging him with being a violent habitual felon?
Well, I think the state hasn't explained why it needed to get that testimony from Mr. Davis as opposed to Mr. Banks.
You know, the question, though, is admissibility. Maybe there's a better way to do it, but is it inadmissible?
Sure, it's not incompetent, but it is not in keeping with this court's precedent around work product to get it in this manner.
Well, the question before us is, was the admission of this evidence plain error? Is it your contention that that Mr. Davis's testimony concerning what Mr. Banks told him was inadmissible?
My contention is that, that some of what Mr. Davis testified to was inadmissible in any circumstances.
Right.
Some of it was inadmissible if the state, I'm sorry, some of it would have been admissible had the state followed proper procedures for getting it admitted, but because none of that happened, and because no effort was made to protect Mr. Farook's rights, and no effort was made to disentangle the inappropriate testimony from what might have been appropriate under some circumstances, the foundation of the trial court's order just falls away.
If there are evidentiary deficiencies in the trial court's order, the usual practice, instead of then looking at what's left in the record and determining whether it meets the legal standard, is to remand the case for a new hearing, isn't it?
Yes, if Mr. Farook does not win on the speedy trial issue, then what the court would do, I imagine, is to vacate the order currently existing on the motion to dismiss for speedy trial and remand for further developments.
And so, I mean, assuming that we were to agree with the Court of Appeals that the trial court committed plain error by allowing the admission of some parts of the testimony of Mr. Davis, and I'm not sure that it has been identified in the record what parts are admissible and what parts are inadmissible. Assuming we were to uphold that finding, was it appropriate for the Court of Appeals to go ahead and then make a substantive ruling on Mr. Farook's speedy trial claim?
My reading of the Court of Appeals opinion was essentially that even if we do consider all of this evidence, it doesn't support the state's position to survive.
Well, but for example, once the state is deprived of the opportunity to, you know, there's no objection at trial. The state presents this evidence. There's no indication that the state at the trial court level had any reason to believe that some parts of that evidence might be deemed inadmissible. Would it not be appropriate to allow the state to use admissible evidence to replace the evidence that was deemed inadmissible?
I feel that the state's had its chance, Your Honor.
Well, I'm talking,
but certainly
for example, we have, you know, any number of cases that say that if the state, if at a jury trial, if the state elicits evidence that is inadmissible, that evidence can be considered in determining whether the evidence is sufficient to support the judgment, that the remedy for that error is not to find that the evidence was insufficient by simply removing it from consideration during the sufficiency analysis, but rather to remand the case for a proceeding at which inadmissible evidence was not admitted, but other evidence might be. Isn't that pretty much the standard process, at least in that procedural context?
I think perhaps I'm getting a bit mucked up here.
Well, I can usually ask a very confusing question, and I'm sorry if I did.
My understanding of what should happen here is that, obviously, if you agree that there was a denial of the right to a speedy trial, the only remedy for that is to dismiss the charge.
No, but let's go back up the analytical chain a little bit. If at the speedy trial hearing, the trial court admits evidence that should not have been admitted, what is the remedy for that error? And can you cite me anything that supports what you're going to tell me the answer is?
Well, Your Honor, frankly, I'm unaware of any other case like this where the defendant's own attorney's been called to testify against him.
For example, what happens in the event that inadmissible evidence is admitted at a suppression hearing, which is also a pretrial hearing before the trial court?
Sure. If, you know, if some of the evidence is inadmissible, I think the evidence that I'm primarily concerned about being, you know, what Mr. Farook and his attorney discussed and what Mr. Davis's trial strategy was. None of that is available through any other source, so remanding it for further development of those facts is not something that is going to produce any kind of result. As far as, you know, remanding to have Mr. Banks and Mr. Poplar and Ms. Garner testify to what their communications were with Mr. Davis, again, I think the state simply doesn't have the evidence to explain this delay. Even if everything Mr. Davis said is true, even if everything comes in, the state has failed to explain the 6-year delay in this case.
Of course, the duration of time alone is not dispositive, is it?
That's correct. No one factor is dispositive in a Barker analysis. But I think what's important about the 6-year delay is not only is that sufficient to move us forward into the rest of the Barker analysis, but it also weighs into the prejudice because it is such an extreme delay and because Mr. Farook was incarcerated the entire time. Barker recognizes, Barker recognizes 3 kinds of prejudice. First, oppressive pretrial incarceration, the anxiety and concern of the accused, the possibility of impairment to the defense. And for decades, the U.S. Supreme Court has said that extensive pretrial incarceration, like we see in this case, implicates all 3 areas. Incarceration is by its nature oppressive, as it strips a person of the liberties and freedoms he previously enjoyed. It also necessarily causes anxiety and concern by disrupting a person's finances and relationships and placing them in both physical and legal peril. And incarceration necessarily limits a person's ability to defend himself, as he's physically incapable of assisting with the investigation. This prejudice exists anytime someone is incarcerated pre-trial, but what matters is how much weight it receives, which is contingent on how long the person spends in jail. And in this case, where the defendant spent 6 years waiting for his day in court, this factor must weigh heavily in his favor. In addition to the prejudice that Mr. Farook suffered as a result of his incarceration, there's also the matter of the state bringing more serious charges based on the same conduct 5 years after Mr. Farook's arrest. And as the Court of Appeals observed, these charges resulted in a much longer sentence than Mr. Farook would otherwise have been required to serve. Johnson counsels that the defendant need only show that prejudice is reasonably possible when the state has withheld an indictment to its own advantage. The federal cases Moore and Doggett both explicitly reject the idea that the defendant needs to give affirmative proof of prejudice to succeed on a speedy trial claim. The federal courts have repeatedly recognized that affirmative proof of particularized prejudice is not essential to every speedy trial claim, in part because the passage of time itself can make prejudice difficult to demonstrate. What has been forgotten often cannot be shown, and similarly, it's difficult to prove what did not happen. We are, in fact, left to speculate about how this case would have unfolded differently had more serious charges been laid against Mr. Farook from the beginning. One hopes Mr. Davis would have investigated the case more diligently had he known from the beginning that his client would be facing a life sentence. We do know he certainly would have been deprived of his excuse that he took no action in order to avoid those more serious charges. And perhaps then, Mr. Farook would have received the speedy trial to which he's entitled under the Sixth Amendment. So, in our Barker analysis, it's important to remember that there are the 4 factors, and they are all interlinked. We must weigh all of them. And so, we begin with the length of the delay. And obviously, over 6 years, it's an exceptionally long delay. It's going to weigh heavily in Mr. Farook's favor. We proceed to the reason for the delay. And the state has put forward in this argument as its primary reason trial counsel's acquiescence in that delay, which for the reasons discussed in the brief can't fairly be attributed to Mr. Farook. The state's also put forward waiting on the DNA evidence. We know the DNA evidence was not critical to the state's case. We also know they got it back a month after they requested it, so that hardly explains the delay. Our next factor is the assertion of right, and while it's certainly true that Mr. Farook didn't make a more timely assertion of that right, there's evidence in the record to explain why that might have happened. It's unclear what a defendant is supposed to do when he's represented by counsel. He's not supposed to file his own motions, and that counsel refuses to file a speedy trial motion on his behalf. So to the extent that assertion of right weighs against Mr. Farook, I think it does so only very slightly. And finally, we come to prejudice, which, as discussed again, must weigh heavily in Mr. Farook's favor. because of his extensive pretrial incarceration. And we see how unbalanced the speedy trial issue is in this case. And the only way to balance the scales of justice, then, is to dismiss the charges against Mr. Farook. I just wanted to say a few more things with the brief time I have left. So regarding the alleged backlog of murder cases in Rowan County. Well, actually, let's back up. Let's go to our timeline. So in terms of explaining the delay in this case, the state has 75 months to account for between Mr. Farook's arrest and the day this case came to trial. And they get 12 free months from Doggett, and that takes us to June of 2013. Mr. Davis's alleged strategy, he testified that in early 2013, he decided to let the case sit, hoping that emotions would calm down. And so Mr. Davis's strategy brings us to January of 2014. There are another 57 months for the state to account for. Next, the state says it's waiting for the DNA results. As we've discussed, that takes 1 month. Therefore, the state has 56 months to explain. And then we come to the backlog. Mr. Davis testifies that there are a lot of murder cases pending. He doesn't say how many murder cases, how long they'd been pending, what efforts the state took to remedy that backlog, or whether those efforts were successful, which stands in stark contrast to both Spivey and Farmer. In Spivey, the state presented direct evidence of how many murder cases were pending, what approach the prosecutor took to clear out that backlog, and the fact that due to limited resources in the courthouse, the prosecutor couldn't possibly have moved any faster. And similar evidence is presented in Farmer, but none of it was presented here. And in Farmer, Justice Morgan found that this factor did weigh minimally in Mr. Farmer's favor because court backlogs must necessarily weigh against the state. And it seems that here, where there's been no sufficient explanation of the backlog, it must weigh heavily in favor of the defendant. The list of cases the prosecution submitted between July 2012 and 2016, it doesn't show that there was a backlog or that reasonable efforts were made to resolve it. What it shows is that Rowan County could try a case if they wanted to. They disposed of 140 cases during this time period, which, as I mentioned before, on average had been pending for less than half as long as Mr. Farook's case. And even if we do assume that there was a backlog, the state's list ends in June of 2016, which leaves 27 months for the state to explain. And no explanation has been offered for the time period between the end of that timeline and Mr. Farook's eventual trial in October of 2018. So, Your Honors, Mr. Farook's position is that whether this court finds that all, some, or none of Mr. Davis's testimony was incompetent, Mr. Farook is still entitled to relief on his speedy trial claim, and the Court of Appeals decision should be upheld. In the alternative, the trial court's order denying the motion to dismiss should be reversed because it's based on evidence admitted in violation of Mr. Farook's privileges and associated constitutional rights. As a final alternative, if Mr. Farook obtains no other relief, this case should be remanded to the Court of Appeals for consideration of the remaining two issues in his original brief. Thank you.
Thank you, counsel. Rebuttal.
Very briefly, and again, may it please the court, the only points I wish to raise here, I think it's been covered pretty well, is that with regard to the issue in Barker of the prejudice to defendant, that last prong, the court makes it very clear the most important one of those is the ability of a defendant to, or prejudice to a defendant basically making their defense. And here, Mr. Davis testified very clearly. I knew where the witnesses were, didn't have any problem finding them. Mr. Cease's only testimony as to that in his argument in the motion was he had one witness that was unwilling to come and testify, not unavailable, wasn't, lost their memory, just was unwilling to come and testify. The other portion is I wish to point out that the Court of Appeals in defendant's pro se motions, his pro se motion was a motion to dismiss for ineffective assistance of counsel. And if the Court of Appeals is going to consider that for his statements in there that he didn't know, then he's waived privilege because it was a motion for, it's either appropriate, that motion's either admissible for all or admissible for none. You can't pick and choose. And lastly, I'm out of time.
You are. Thank you, counsel.
Thank you.
Thank you to everyone. Madam Clerk.
All right.